motion was made by Commissioner Gonzalez and seconded by Commissioner Ishii. So, what do you guys want to do? I'm gonna make copies right now.
There you go. All right, anybody else? Ready? Comments? Before? No? Wally? Don't say anything? All right, well, great. I think we're all in agreement. If we vote on this today, we're gonna end up in court. We're gonna end up having an appeal. We're gonna end up back here doing this again. Um, I'm personally not real thrilled with the way this is going. I mean, this has been, what, 4 months already? 4 or 5 months. A lot of time, a lot of effort, a lot of feelings. You know, not good feelings. I kind of feel intimidated. You know, so I know how you guys feel. I know, what some of you folks are saying. But this is where we're at. And with that, Mr. Chairman, I would like to withdraw my motion to deny.
And my second, Commissioner seconded. Are you okay with that? Do you agree with that?
Yeah, I would like to withdraw my second to that motion. And again, we're trying to give everybody a fair shot at the whole process. We're not trying to take away anybody's rights and privileges under the process. And I think we need the right information, the right questions to be asked and answered, and then we come back and make the right decision at that time. So I remove the second to the motion.
Okay, thank you very much. So the motion has been withdrawn. Are there any objections from any other commissioners? No objection from me. Okay, so now what we're gonna go into our petition for standing for a contested case. Can I please call up Jonelle Fukushima, please? And can I have Miss Monica Morris please come up? And question for Mr. Darrow. What is the procedure process of filing for the petition for standing? What are the dates? When is it postmarked? Is it when you received it, when you filed it? And did this petition make it? Ivan, please go ahead.
Sure, just going back to Rule 4-6 again, it says that, again, so that in all proceedings where the commission's action is directly appealable to circuit court, the applicant and the grantor will be designated parties to the action. Any other person seeking to intervene as a party shall file a written request on the form approved by the planning director and accompanied by a filing fee of $200 no later than 7 calendar days prior to the commission's first reading of the matter. So basically it's that any person seeking to intervene besides the applicant and the director needs to file this form no later than 7 calendar days.
Okay, Mr. Rai or Mr. Darrow, maybe if you can answer my question and just, what is the process, times, dates, whether it's postmarked or whether you receive it from the hearing that we're in now, because we did start the hearing. Maybe we can just go over that first before I ask questions.
Thank you, Mr. Chairman. The question is whether or not the application was filed within 7 days prior to uh, this planning commission meeting, based on the fact that this was the meeting that they were instructed to send out a request for a petition for standing because of the fact that there was information given before that was incorrect. This particular, we now have two petitions before us. This one from Janelle Fukushima was received in the planning department March 4th, although it's post-dated on the envelope as January 28th. I'm sorry, February 28th. So if this is going to be given to legal interpretation, which I would have to defer to our corporation counsel in terms of whether or not we can consider the postmark as being filed within 7 days. If we consider that, then it would be time. If we do not, and we look at the date it was received, then it would not be time.
So the record state from it was when it was received. That's what it states.
It says filed.
Filed, received and filed.
Well, it just says filed, and that's why it's a matter of interpretation whether or not filed means received at the planning department or postmarked.
Thank you. Irene, would you like to continue that? Or, what Ms. Morris mentioned was, her interpretation was postmark. Is that correct? Yeah,
I live on Oahu, yeah. So my understanding talking with my client at the school was that their understanding, and they probably would need to clarify this, was that so long as it was postmarked by February 28th, it would meet the filing requirement.
If I might, too, part of the requirement for the petition for standing requires that a notary sign on it, and that would confirm the date of the notary was 7 days prior to the hearing. The other component here is, I believe, the following was a furlough for the county, so it would have been received the next day, but because it was a furlough day, they didn't receive it till that Monday.
Ms. Fukushima, I need to swear you in. Can you please raise your right hand? Do you affirm and swear to tell the truth in front of the Hawaii County Planning Commission today?
I do.
Question that I have for you is, what is your relationship with connections? Because you do reside on Wainui Avenue.
Correct.
And so what is your relationship with connections?
I am first of all, I am a Kaumana resident, but currently, as of 1 month ago, I joined the board of connections of the Trust. So that's my relationship with this. I'm a new member.
Okay, so this petition for standing was submitted by you. But Ms. Morris has mentioned in her testimony earlier that she's helping you submit.
There was not clear, there wasn't very clear or guidance about whether I should do it on behalf of myself or for the fact that I'm now currently a board member. And so it would depend on the outcome about which way I would choose to go individually or to choose to be part of it.
Okay, well, we just received another petition by Mr. Gomes, Mr. Jeff Gomes. And before we get into that one, we need to take care of this one. Mr. Ishibashi?
I just had one question. Would it be necessary to have you as a grant you standing in this case?
As Monica said, for the fact that we wanted to make sure that all bases were covered and doing the right right thing and following the rules. We really didn't have the proper guidance at the time or people to really ask which way we should go. So I filed that to ensure that we would have timely ability to continue.
We already have two already that are automatic.
Okay.
And if I can just clarify, with respect to my representation of connections, my interest is in representing the school, not in the individual, but the school. With respect to the petition filed by Ms. Fukushima that was sponsored by my client, again, as I said earlier, that was just to ensure that the school's interest in contested case procedures were ensured, because there was confusion with respect to that. But what I want to state unequivocally is that my interest is in representing the school. So long as they have automatic standing, which has been confirmed today, that is my interest with respect to that.
Ivan, you want to add to that?
Okay, so, here's Ms. Morris. I don't know if this is something you want to discuss with Ms. Fukushima or not, but you're just wondering if it's necessary for the commission to take up her stand if the school is already automatically part.
As far as the interest of the school, as long as they're an automatic party, then that's my concern.
So I guess the question then for Ms. Fukushima is, if the school's interests are protected in that way that they're an automatic party, you still feel that you need to be admitted as a party. Would you be representing yourself or would you be an attorney?
No, I think that as long as it's covered, then yes, that's
Okay, so you would like to withdraw
Yes.
your petition for standing in a contested case.
Can the school get its $200 back? It's on a real bare bones budget. I just think
That's for our planning department to decide.
thank you very much.
Yeah, actually, the rule says that if the request for intervention is withdrawn in writing before the commencement of the hearing, the filing fee shall be refunded to the person's requesting.
Oh, may I say that I did not, at the time when he said, that I would be withdrawing it, and the rules have been just a little ambiguous, so to speak. So, whether I'm an individual or have interest in the school, I feel like I would still put that in writing. I just don't have that available. Most people understand that would be the process.
Does the school get its money back? Is that what I heard you just say?
Actually, the rule says, this is just what the rule says, if a request for intervention is withdrawn in writing before the commencement of the hearing, the filing fee shall be refunded. So,
That's a contested case hearing?
well, technically, the whole hearing is a contested case hearing, in the sense that it is the final hearing before a decision is made that can be appealed to court. So, well, I guess. At this point, I think we have to leave that with the planning director and necessary consultation.
Thank you very much. Thank you.
Any more questions for? Okay, thank you guys. You guys didn't see. Okay, we just also received another petition, and staff, have you received a $200 check?
We have, there is one deficiency with the submittal. If you look on page 2, you'll notice that the notary public put tomorrow's date, unfortunately. And so at that point, and then it was also received today, as of today's hearing. So if you're considering this petition, it might be more appropriate to have this redone and have it correctly placed on the notary. But again, we do, this was received today. And it didn't come with the $200 flat.
Okay, with that said, our rules state, Mr. Gomes, that, it needs to be in prior, it just didn't make it, it was submitted today, and because of also the other deficiencies on the application, we will not be able to accept it. And, Mr. Funke, please come forward if you wanna say something. And then after that, Ms. Amy Self and BJ also come to.
Mr. Chairman, again, for the record, Sidney Foote. From the get-go, I guess this application from processing standpoint has been so topsy-turvy. I mean, if you're going to just look at the rules themselves, I mean, I can just cite you, for example, it's like the applicant shall serve notice to surrounding property regarding the contested case hearing. Who sent the letter? Planning board. The other thing too is like, it says like, well, shall file a written request in form 7 days prior to the commission's first meeting. We can debate whether this is the first meeting, the third, or the fourth, or whatever. I mean, like, bottom line is that there's like so much interpretations and misinterpretations as far as what the process is. So I guess all Mr. Gomes is asking is that, fine, if it's going to be denied, then I guess the only recourse is that after you go through all this contested case hearing, then they'll just file an appeal that he was denied the due process. I think for the most part, if you look at due process issues, the concern is more as it relates to the intervening parties, or at least the parties that are parties that are not the applicant. In all of the court cases, not all, but many of the court cases that, for example, was cited today, they deal like with not the applicant, they deal with other parties. So if you deny Mr. Gomes an opportunity to be a part of the proceedings, then I guess the community and everybody else would have to resign and just providing their testimony through the public hearing portion all over again. Unless the record is already there, that you can, for the commissioners or the hearings officer, just accept whatever is already provided as being a record. So having said that,
Mr. Gomes, can you raise your right hand? Do you swear and affirm to tell the truth in front of the planning commission today?
yeah.
So, a microphone, please. Please state your name and where you reside, and maybe just explain to us the reasoning for your petition.
Sure, Jones. I live in Kaumana. My reasoning is I'm not sure of what the procedures are, and I don't have an attorney, so I'm still not exactly sure what my rights are to. I feel like I'm defending my home and my family, and I'm just asking you for the opportunity to let me be a part of this process. That's my understanding of what a contested case hearing is. I mean, I've asked Sydney to try and explain it to me. And I kind of have an idea of what it is, but I'm not sure. Up until today, I thought a contested case hearing was going to be in front of a court. I didn't know that until Sydney explained it to me again. So I want to be a part of the process. I want to be able to ask questions about what was done, what should have been done, because I follow the process. I'm part of it. I'm physically, mentally, and emotionally affected by everything that's been going on. Myself, my family, and my neighbors. And I'm asking you to let me be a part of the process.
Any questions for the also petition? The attorney for the county planning department and our planning director, would you guys like to add to Mr. Gomes' request or petition?
Only to state that the planning director has no objections to the intervention of either of the applicants, either of the petitions to intervene. We have no problem with that.
well, from a procedure standpoint, um, and our rules, as our commission attorney has stated, that it doesn't make it, it doesn't meet the criteria. Um, so what I'm looking at is to deny, to not grant standing. Yes, yeah, yes. Well, that's what I recommend, and it would have to be a commission decision. And planning director, would you like to add?
I may not have an accurate memory, but I believe that in the past, prior planning commissions have allowed people to intervene, even at, the 11th hour, so to speak, as opposed to enforcing the 7-day requirement. That's entirely within your call. However, just as stated by the representatives for the applicant, in an abundance of caution, I would hate to go through a contested, denied standing, go through a contested case with connections, then end up having an appeal, go to court, and have the court say that despite the rules, we should have given standing given the convoluted and confusing manner in which all of this has played out. And so it's kind of like, what harm does it have to the applicant if you allow Mr. Gomes to intervene? Because if you deny, given this strange procedural history that we have here, and we end up in circuit court, and circuit, we go through this, and one way or another we get a decision, because we haven't even addressed whether, I think, at least I haven't heard conclusively whether you're hearing it or whether it's going to a hearings officer. But you could go through this whole deny standing, go through this whole process, and then go to circuit court, and the circuit court says, because you're dealing with pro se, somebody who's not represented by counsel, because you're dealing with something that got very confusing, that we should have erred on the side of caution and allowed him. And I hate to go through all of this and then have a remand to then allow Mr. Gomes to have standing. And I'm just saying, I don't know what a court would do, but I'd rather have him in and delete that as one possibility for appeal than deny and then have that hanging over my head like a sword. Thank you.
Mr. Hall, where is your applicant's position on Mr. Gomez's petition?
I think the planning director's perspective is entirely reasonable, but here's where I'm coming from. The notary page says is defective, and it's defective as a matter of law. And my suggestion is that maybe the planning department in the future take off the requirement for the notary. But right now, and this is actually a mistake that could affect this individual's right to be a notary, because this is completely wrong as a matter of law. I mean, if the rule requires a notarized petition, I'm sorry, but today's March 7th, and this notary can be held legally responsible for this. But again, I hear what Ms. Leonard is saying, and I think that's reasonable. I'm just coming from the procedure, and this is inherently
Okay, Mr. Hong, if we were, if this commission, if this body was to grant standing to Mr. Gomez, how will it affect, or maybe I should be asking Mr. Fukushima, how will it affect your stance on that? Because we want to err on the side of caution, and since we're giving a break to somebody else, and this is the same special permit that we're going to do. How do you feel about? Well, I mean, connections, and you represent connections. No, you represent Cedars. Yeah, I'm just a little bit confused here. Who's
Mr. I think when in our discussion with the AG and Mr. Kushima, it seems like Ms. petition was filed was an abundance of caution to make sure that people will see this and the school were represented as parties, and since they both are them, they felt that it was okay for her not to get stuck here. So, I think if you guys, you've heard some expressions of the need to be flexible and equitable in this kind of situation. So you may want to consider that if you need another executive session, we can do that too.
Commissioner Moses?
Yeah, Chair, is it possible to have somebody explain for the benefit of Mr. Gomes what the contested case is and what the procedures are and what happens in a contested case? And is that possible? So
Yes.
that he has understanding of exactly what happens and what occurs?
Yeah, we have a room full of attorneys, so thank you,
Mr. Rose, I assume that you said you got to talk to Mr. Cookie already. Mr. Cookie is pretty well informed about this process. But we generally understand that in a formal contested case, this can be as informal as the parties agree, or it can be very trial-like. Allows for things like parties calling witnesses and asking questions, just like the court testify, and allows for the other parties to cross-examine the witnesses, ask them questions, to test what they're saying, credibility. Also allows for the parties to ask for a subpoena of the witnesses or other witnesses if necessary, and things of that nature. And so it allows for development of a relatively full, almost trial-like record if that's what the parties want to do. So just so you understand that that's the kind of thing that this case is likely to entail with all these attorneys involved. And probably the main reason why people also request standing is so that they will have the right to pursue appeal to court if necessary for the final decision. So I guess the chair, Commissioner Moses, just wanted to make sure that you understood the kinds of demands that would be put upon you if you were a party to a contested case, and that oftentimes people will hire an attorney to help you with that kind of thing.
Thank you very much.
Mr. Wright, where are we with the contested case of possibly having one, two, three, four contested cases with this applicant? I mean, do we have enough money in our funds? It's all going to be one contested case.
We do have the ability to hire a hearings officer. I cannot guess as to the rent of the hearing itself. We've had recent hearings that have gone from a little as $20,000 for a particular session up to $40,000. All I can say at this point is if the commission elects to refer this contested proceeding to a hearings officer, you will get a hearing officer for it. So don't let that be weigh on your judgment.
One other factor that may into the kind of contested case that happens is the extent to which the parties might be agreeable to using some of the existing record rather than doing everything all over again. So I'm wondering if we ask the parties if they would be agreeable to doing that to the extent that it's practical.
Yes, if all parties are agreeable to use the existing record as a basis for the contested case proceedings.
Speaking on behalf of CBES, I don't believe that I'm trying to extend or I don't want to overcharge my client, obviously. Yeah, I'm not going to try and increase the bills on behalf of my client to the extent that I can use part of the record. I obviously want to use part of the record, but I know that what is absent from the record is our ability to challenge the credibility of some of the allegations made and what the accuracy of those allegations have been. So insofar as that is concerned, I'm not going to agree to anything that would to have unsubstantiated testimony that was given in a public hearing used against my client without me having the opportunity to cross-examine that individual. So yes and no. And obviously, I don't want to have to spend any more time in an contested case than I have to. So I'm going to try and, on my client's behalf, make it as efficient as possible.
Thank you. I would likewise want this to be acted upon in as efficient a manner as possible. Time means money for my client. There's an application that's being prepared to the USDA for low interest loan so that facilities could be built should the special permit act be approved. So, so, so a drawn-out process would not be to the benefit of my client. So I would agree to the extent possible to move this along as quickly as possible and without waiving my client's rights and interests, whatever can be used, provided on the record previously would be to the advantage in moving this along as efficiently as possible. What I'd also kind of like to express a concern is that I know with respect to pro se persons who are not represented by counsel, courts are generally very liberal in allowing latitude to them because they're not represented by counsel. What I would, however, urge that whoever is presiding over the contested case, that there not be undue delay associated with a pro se party. So again, if I could just ask that this matter be moved along as quickly as possible without compromising my client's due process rights.
Commissioner Ishmael.
The intent is not to stymie or hold back any participation from the public.
Not at all.
So because they're on the record, they have the right to be cross-examined and tested.
Okay, so all parties, myself or BJ, where is our position?
Well, I think that everything that's been on the record already is gonna be a part of this because you have each of the testifiers who are sworn under, or testified under oath. It's public hearing. All of these have been public hearings, so I think that information that has come before you already would automatically be part of the record. I guess you could, I guess the parties could decide which parts they want to move into evidence during the hearing. But as far as well, that's the only thing we had to add.
This commission, this body needs to decide if Mr. Gomes' petition stands, if we can give it a stand. And what I'd like to add to it is, because we're possibly doing that, then I want to offer it to Ms. Fukushima as well. We want to, just like our planning director said, to err on the side of caution, and I understand there's no reason to because CBS and Connections is already, they already have the contested case we're offering. So, if this body chooses to.
Are you requesting a motion?
No, we don't need to request a motion for the petition.
Well, if it's necessary, I'll make a motion that we grant standing for Brother Gomes.
Second.
If it's necessary, if it's not because it's part of the record already,
You should have a motion.
I make a motion that we accept Jeffrey Gomes' petition for standing in the district.
The motion by Commissioner Ishibashi is to grant standing to Mr. Gomes.
Yeah, Mr. Chairman, staff suggests, and I think it's a good idea, that if there's going to be a motion like that, that it be conditioned on Mr. Gomes getting that notary corrected.
I will.
And that should be done, what do you think that should be done today? So,
Okay, so there's a motion, Commissioner Ishibashi, and seconded by Commissioner Moses. Discussion? Yeah, guys, this has been going on. It's pretty crazy. We have a lot of things that we're looking at, and just like I said, I think we need to err on the side of caution. So we'll take this motion first, and if there's no other discussion, we'll vote.
Thank you, Mr. Chairman. The motion before us is to grant standing in a contested case to Jeffrey Gomes. With that, I'll take the roll call. Commissioner Ishibashi.
Aye.
Commissioner Gonzalez.
Aye.
Commissioner Moses.
Aye.
I'm sorry. I was out of order. Mr. Chen.
Aye.
With that, the motion passes 4-0.
Notified in writing, and thank you. Now I'd like to entertain a motion to grant Ms. Fukushima petition for standing, if she chooses to. If she wants to, maybe if Ms. Fukushima. Okay, but it is on the record that, can you just come up, let's begin the record. You're sworn in, so you can vote.
Thank you. No, I do not wish to have my, I wish to withdraw. I do have a comment though, as a private citizen, and kind of observing. Not only is it eye-opening, but it's very interesting to me how the rules may change. I understand in the nature of wanting to save time and all the projected where it may end up and what the court might say and whatever this, it's disturbing to me, just as a private citizen, not in connection, my relationship to connections, but as I raise my children in this community. I think that had the shoe been on the other foot, had maybe it been me that had turned it in, because we were talking about the postmark, the notary of my which I read what you read. I had the opportunity, I took time off of my job to go pay for the notary, to do the best that I could with it. And you're right, a lot of the information was not forthcoming or easy to understand, but I did the best that I could as a single mother of 3 kids and a business owner to make the time to try to find out the best information I could. And so for future reference, I'd like to say that it isn't fair to me as a private citizen. I'm fighting for the rights of my children as well, born and raised in Kaumana. And so I would say to you, Mr. Coopens, as well, that it saddens me that our community of Kaumana and the way that you guys talk about community, you don't represent the entire community of Kaumana. There are a great many people in Kaumana who have not come forward to speak out of fear of the backlash from the minority of those who are speaking here today. I being one coming forward, I just wanted to say, future reference, it just felt like a big waste of time that I had to go out and do that and jump through the hoops to get my, Anyway, thank you very much. I appreciate it. Thank you.
Yeah, Mr. Chairman, I just wanted to confirm on the record, make sure that there's no question with the commissioners that the CBIS and the school connections itself are automatic parties to the contested case.
Yeah, So, fellow commissioners, so we are well aware of that, right?
Yes.
Okay. So the next thing we need to do is we need to decide as a commission if we want to be the hearing, if we want to hear this petition, or if we want to hire a hearings officer. So we're ready to entertain a motion.
I make a motion that we have a hearings officer,
We hire a hearings officer.
that we hire a hearings officer.
Second.
Okay, discussion. Uh, Yeah, with what Mr. Rice said, that we do have the resources, that is limited, but we do have the resources. I think that would be the smartest thing to do, considering how this whole applicant is going. Commissioner Moses?
I do have a question though, and maybe you can clarify. We talked about the record, what is going to be given to the hearings officer in this contested case? And is it, you know, it was asked if, what should be given as far as record. I'd like to see the entirety of the record be given in its entirety.
Well, we do have the entirety. I got a big box back here. If you look at it, and but we do have our CDs. So the hearings officer, if we choose to hire a hearings officer, the hearing officer will get all that information. A CD was submitted to us. I believe it's like 2,000 pages. Things that we've been receiving for the last 4 months. Maybe going into the first hearing, we got all these binders. So I hope that answers your question. Maybe Ivan can interject.
I just say that, yeah, the entire record is what it is, but in a contested case hearing, there would probably be some discussion about what parts of it should be given formal status as it's and what kind of cross-examination may occur. So there will be some discussion about the weight and importance, credibility of evidence in the course of this case.
Thank you, Ivan. Good question, Commissioner Moses. Yeah, there's no other discussion. We'll take a vote. Mr. Darrow?
Thank you, Mr. Chairman. The motion before us is to hire a hearings officer. With that, I'll take the motion. The vote, Commissioner Moses,
Aye.
Commissioner Ishibashi,
Aye.
Commissioner Gonzalez,
Aye.
and Mr. Chen.
Aye.
The motion passes 4-0.
Everybody will get notified, right? Thank you. For all parties, CBES, Connections, County of Hawaii, Planning Department, petitioners, Mr. Gomes, Ivan, does anybody have anything to say? Put it on record now. Any other issues? Mr. Hong?
I'm sorry, just being too fundamental, I'll reach back. Was there a motion to, grant a contested case hearing? Is that necessary, or?
I don't think that's necessary.
Oh, good, okay, sorry.
And if any of the commissioners disagree, then we should come down. It's inherently a contested case.
Sorry, thank you.
Mr. Gomes?
May I retrieve my original petition of the current?
Yes, in the original petition, I believe Mr. Darrow has it. And anybody else? Okay, well, thank you very much. See you guys later. Everybody will be notified you're ready. Thank you. Okay, guys, let's just power on through this. Let's go right into our minutes.